This is the Asset Protection Show. Expert strategies by attorney John Skabelund.
Welcome to the show dedicated not only to protecting your assets from lawsuits and creditors, but also protecting your legacy. After all, what we do isn't just for ourselves, but to create generational wealth. Now, an asset protection plan is not enough. Today, we're going to discuss how estate planning will provide you full peace of mind and safety. I'm very excited to introduce our guest today, Mark Bregman. He is a principal at the law firm of Dyer, Bregman, Ferris, Wong and Carter. That's a mouthful there, Mark. He's been practicing for 45 years. He does not only estate planning, but he has also done estate litigation, estate tax planning, and administration. And that's why I'm really excited. We've known each other for years now, Mark. You're a great friend. Thank you so much for being on the show.
My pleasure. I'm happy to be here.
Let's start with the basics. Tell us, what is an estate plan? What does that mean to you?
Well, when I started doing estate plans many years ago, I thought it was a will. And then I graduated to where it was a trust and a will. And then I graduated to where it was a trust and a will and powers of attorneys. And today, estate planning is having a conversation with the client to find out what their hopes and dreams and aspirations are. And then we fit the plan around the client rather than fitting the client into the plan.
That's great. What are some of the common components or documents in an estate plan?
Well, most clients are going to get a trust, a will that we call a pour-over will, because the will is only used if there's some asset that wasn't properly funded into the trust, and then a financial power of attorney, a healthcare power of attorney, which I think is one of the more important documents, and then a living will, which is a document that says, don't keep me alive if I'm not going to have a good quality of life. And then the key component of estate planning is collecting a list of the client's assets, how they're titled, how much they're worth, and then formulating a strategy for what we're going to do with those. In some cases, we may just do a beneficiary deed, which is a deed to your house that says, when I die, my house belongs to the next person. Those are particularly good plans for a lot of our older clients, that they may have a house and they may have an IRA and they may have a small investment account because they've spent their money enjoying their life in retirement. And then we can give them a really basic, simple plan where the IRA goes to who they want, and then the beneficiary deed goes.
That makes a lot of sense. So
the caveat with that, though, let me just add, those aren't for everyone, and you have to be very careful, because an important part of estate planning is how you pass that money along. In beneficiary deeds and IRA designations, the next person gets it with no restrictions. If there's a special needs child, or if there's a spendthrift issue, or the most common one is, I don't trust my son's wife or my daughter's husband. And, depending on the amount of money, a small amount of money is very important to people that only have a little. People with a lot of money have different concerns, and that's all part of the counseling process.
That's a great point. So the point of, or the purpose of an estate plan is to do what exactly? What are we trying to avoid?
Well, we're trying to do two things. We're trying to create a plan for transferring our wealth to the next generation. But more and more people are recognizing, as we live longer, they also have to have a plan for what happens if they become mentally incapacitated. Maybe Alzheimer's, it just may be aging. So we have to take those things into consideration. So when I first started in 1980, and my competitors were advertising wills for $25 in the penny saver, we didn't think that much about it. But today, a couple will come to us when they have children, and then they'll come to us when they retire, and then they'll come to us when the first person dies. Sometimes their second marriage is involved. All of those things suggest different ways of dealing with it that you can't know that and pull something down from the internet and think that you're done. Estate planning, I use the analogy of an iceberg. We only see the tip of the iceberg. 90% or more of all people die and everything goes smoothly. Either they don't have enough to fight over, or they've got a decent plan, or they've got families that get along. And then do you need sophisticated planning? No. But then there's tax issues that are come up both in income tax and estate tax. I mean, we see any number of clients in the course of a year that come in and say, "Oh, I live in the house that's been in my family for 4 generations, and I want to get a mortgage." And it's like, but the house is in the name of my great grandpappy, and there's 74 descendants of my great grandpappy that all have an interest in this house.
Right.
We see a lot of things like that we try to clean up before it becomes a problem.
Yeah. So as you know, I've done estate planning as well for years and no longer do that. But to succinctly sum it up, listeners, you need to have an estate plan, not only when you die. And I think, Mark, you would say that's when most people are thinking, oh, in the event of death, what are we doing? And it's important that we are avoiding probate, which is a court case where the local county courthouse is now administering and supervising your estate, and that's costly. And the other issue that leads to, which I'm sure you can talk about, Mark, is that when you have a probate open, now it's so much easier for loved ones to fight over your assets. So everyone, when we think about asset protection, we think about how do we protect our assets from lawsuits, the car accidents, the malpractice, right? But have you given thought about when you die, what would you do if your loved ones are fighting over your assets, depleting your assets? And most of all, remember, we're leaving a legacy. Mark, what is your advice there to clients who are wanting to leave a legacy and trying to minimize the chance of litigation occurring after they die?
I think that one of the more surprising things in my practice is when somebody says, "My 2 children don't get along, so I'm going to make them both co-trustees or co-executors." And it's like, well, what are you talking about? And the corollary of that is, I have 3 kids, and this is the one that I trust to divvy up my estate 3 ways. And, and I can tell stories all day long about the 2 that you don't pick, don't trust the one that you did pick.
Right.
And it becomes very expensive with or without a trust. Although I'm considered a trust-based planning attorney, we still do a lot of probates because people forget to put things in the trust, or they have issues that require court approval. But we do the best we can to analyze and make sure that the clients have the information that and so let's be serious. Most of my practice and most of your practice, we're dealing with wealthy people that have money. The people that need a simple will and they have 2 kids that get along, that's simple. We make sure that they have a good financial power of attorney and a healthcare power of attorney so that they don't run into big problems, because now those problems are even bigger because they need a healthcare agent and they don't have one, and they don't have the money to go through what you have to go through to get a conservator or a guardian appointed. Well, we can solve that problem for a fraction of the cost. But really, we're talking about people of wealth. And when I started in this business, that meant you had $1 million. If you had $1 million, you were going to pay about $200,000 in estate taxes. That's 20% of your estate. Today, a married couple can have almost $30 million before they have to be concerned about taxes, estate taxes.
State taxes,
But
yeah.
but that doesn't mean that they don't need to worry about step up in basis and making sure that their assets are positioned properly. Uh, and most importantly, I reviewed a trust yesterday where the attorney had put in, everybody's gets along, and the draft that I looked at, he gave the beneficiary the right to withdraw the money. And well, as you know, as soon as you do that, the creditors have their foot in the door. So even though that trust might look like the next trust, just that one line, you have to be very careful about that. Healthcare powers of attorney and considering how you're going to arrange your estate. It used to be everybody got what we called an AB trust, and we have a lot of family trusts or decedents trusts out there that aren't serving any purpose other than increasing capital gains tax. So, again, you can't find that information on the internet and draw down a document. And it's self-executing in some sense. Somebody with $20 million can afford to pay $10,000 or $15,000 to get something that somebody else might only want to pay $2,000 or $3,000 for. And that may be all it's worth to the person that wants to pay that. So
Let me make sure I'm hearing you correctly. So, as you said, we, of course, are always wanting to avoid probate upon death, but you raised the great point. The other concern we always have, everyone, is what if you become incapacitated, either mentally unable to manage your financial affairs or become physically unable to take care of yourself? So, Mark, that's a great point about the healthcare power of attorney. But let's talk about does a client know who to go to? So you had mentioned some low cost or no cost options. I'm sure we all can think of these online solutions. Well, there's paralegals, there's document preparers. Mark, can you speak to that? What should a client use when creating their estate plan? And if they're going to use an attorney, why? What's that benefit?
Anyone that's listening to this podcast is not going to use a paralegal or a document preparer. No matter how good they may be, they can't give legal advice. All they can do is give you documents, which means the one question that people can't ask me, they can't come to me and say, I want a trust. That just opens the door to a much larger discussion that, they leave with their head swimming because they didn't realize there was so much more to it. And this has been true for my entire practice of law, and it applies to choosing a doctor or a dentist or a financial advisor. Don't leave your common sense on the doorstep. If you've earned or inherited enough money that you need an estate plan, and everyone does, that you have enough common sense that I say people know within the first 30 seconds if they want to work with me. It doesn't matter if I was referred by your best friend, and most people that come to me have been told that I'm the best lawyer and I'm the only one that can do this. But don't leave your common sense out. If you don't like what I'm suggesting, don't hire me. And we make that point. But you can read in lots of places how to do that. And you can tell the people that have done their research. They come in and they say, what law school did you go to? Where did you graduate? What is your experience? Tell me about a couple of your cases. I've told you a little bit about myself. Are you comfortable handling cases like this? Those are all good questions, but they're all designed to help you exercise your common sense. There's no magic formula, and I'm not the best lawyer for a lot of people. We have a issue in our office now where in an estate administration, and I sent the preliminary inventory that I was working on to the other side, and the client just was incensed because my partner had told her that we're not going to give them that information, and it just never occurred to me. I said, well, we can say we're not going to give it to you, and then you're going to get sued, and then we're going to give it to you.
Right.
And it's like, wouldn't you rather just give it to them? And I dig into, and that's a recurring theme is don't tell me what to do. Tell me what you want to accomplish, and then I can tell you how to do it. And you may remember from your days in wealth counsel, we used to say, you teach me about your family and I'll teach you about the law.
Mm.
So ask those kinds of questions, but most importantly, don't hire a lawyer because your friend liked them, and use your common sense.
I agree with that. I would add, as a former estate planning attorney myself, you would know, Mark, that not all estate planning attorneys are cut from the same cloth. There's good ones and there's bad ones, just like there are good doctors and bad doctors and good dentists and bad dentists. Things, I'd be curious if you agree, but things that I found that most estate planning attorneys frequently overlook is that discussion of incapacity. How are we determining whether you're able to manage your financial affairs? Often that discussion's not even had with the estate planning attorney. And then the follow-up to that, of course, is so who's going to manage your money for you while you're alive but unable to take care of it? Who do you trust? And that person, as you know, Mark, would be very different sometimes than the person who we called the successor trustee that would have managed the estate after death. But questions like, there's a whole host of questions we could dive into that most estate planning attorneys just never get into. So let me ask another question. Is there any other advice that you would give to someone who's meeting with an estate planning attorney to see if they're really experienced and competent? Because just because you've been doing this for 40 years doesn't mean that you're sharp. Any other advice or questions you think the client should be bringing up? Red
Well,
flags.
part of the problem in my practice is clients don't know what questions to ask. And if the attorney doesn't raise them, then they never hear about them. But to answer your question, no interview with an estate planning lawyer is complete until they've talked about not only incapacity, but the family and gone through. Let me tell you, here's what's below the bar. Below the bar is you meet with an attorney, you tell them your net worth, and they say, who do you trust most? Come back next week and I'll have a full set of documents. And those documents will be very good. They just won't fit everybody. So you want, it's not only a question of incapacity, but who's going to take over, and how are the people that are going to take over going to fit with the other people in your life? We send a lot of people to trust companies and licensed private fiduciaries because the biggest complaint about using outsiders is it's too expensive, and of course but what's the cost of it going sideways? That's really important, and it's also one of the conversations that we often have is I used to say, if the clients don't cry during my interview, then it wasn't a good interview. You have to talk about the hard things. That's, we as lawyers have to make our clients face the reality of what might happen, because if it doesn't happen, that's great. But if it does happen and you haven't talked about it, it's a problem. So, uh, you know, some lawyers will go up to the line, but they're not comfortable having the serious talk. The clients will say, "Well, I want to stay in my house." Well, is that realistic? Is it realistic financially? And is it realistic physically? Let's talk about it. Yes, everybody wants to stay in their house as long as they can. But where is the bright line? I used to think so I'm 74, still practicing pretty much full time. If you had asked me a few years ago, I would have been in that group that scoffs when you see an obituary about somebody dying at their desk. And, dying at your desk used to mean that you didn't go out and enjoy life. Now I've learned dying at my desk means that I had my mental capacity right up until the end. And that's, where is that? If you don't engage in that conversation as part of the estate planning process, nobody's going to know when you've crossed the line. And you have to be able to say, do you trust your kids to do the right thing at the right time? That includes taking away your car keys, because when the time comes, you're going to say, I can still do this. And that's where you find the people, at all income levels. They died in a car accident, hopefully a one car accident, but often that's not the case. You shouldn't be driving, and now, of course, we used to talk about the Jackie Onassis case and things like that. Now everybody's talking about the Gene Hackman case, where his spouse, who was 30 years younger, was taking care of him, and he had dementia. She had a stroke and died, and he was living in the house. Their dog died of dehydration because he didn't know to feed the dog, and there was nobody checking in on them. Right. What kind of support system do you have? And I think it's important for people to recognize maybe you belong in a facility where you have a panic button and somebody's going to check on you if you don't come down to breakfast. You can't rely on your daughter, who you talk to every week, who lives 3,000 miles away, to know if you've had an incident. So that's all part of estate planning, is bringing to the client's attention what those issues are. The best clients are the ones that say, well, what else am I not asking you? Those are the best clients. The ones that know that they don't know everything, and that's the opposite end of the range, where somebody comes in and they're looking at their watch and they want to get out of there as soon as possible, and they want to know how much is it going to cost and how quickly can you do it.
Great point. You raised something that is a common question, and that is, how often should clients be updating their estate plan? And I know there's no bright line answer to that, but what are some life events that you've noticed in your career, Mark, that really should trigger a client to go back to their estate planning attorney and update the plan?
Well, you're asking a question that I struggle with. Lawyers, of course, like to say you should update your plan every 3 to 5 years. Some lawyers have programs where they do something every year. But frankly, life-changing events. I always tell my clients, I don't send out, and I did this for many years, but I no longer send out an annual letter and like CPAs that tell you what the changes are, because there's never any changes that are going to affect you as far as estate taxes that you don't know more about or know more in advance than I do. If you have a triggering event, like you're going to sell a business, you have the birth of a grandchild, you have the death of a child. Those are all reasons to consider coming in and just talking about, does my estate plan already cover this, or do I need to make changes? Getting a divorce, getting married, retiring. Anytime you have a life event, uh, hopefully most of the people that will be listening to this have a lawyer, whether it's an estate planning lawyer or not, that you can pick up the phone and you can ask. You don't have to wait until your hairdresser tells you, I have a friend, you need to see a lawyer. You should be able to have access to somebody to say, do I need to make a change? So I don't like to put a number of years on it. 3 years, probably too soon. 5 years, probably about right. We get a lot of clients we did estate plans for 10, 15 years ago. Dad has died, mom is getting older. All of those are good points to check in. But law is a little bit different than medicine. Medicine, I get an annual physical every year. And I know it's time because I just went to refill one of my prescriptions and they refilled it, but they gave me no more refills. That's my cue to call the doctor to go in. With lawyers, you shouldn't have to make an appointment and go in and ask a lawyer, is there anything I need to do? You should be able to pick up the phone and have a call. We pride ourselves on being available to our clients to have that. We get emails that say, "Oh, I want to add 3 grandchildren" or something like that. So
Yeah,
if you don't know what your estate plan says, it's probably time to come in.
good point. I would just add to that, realize, listeners, that when you're making an estate plan, some of the hard choices you're going to have to make is not only who the trustee or executor of your estate will be. If you have minor children, it's who will be the guardian and raising those children. And I found in my practice, Mark, that was often the most difficult decision for clients to make, is who will physically be raising minor children if they pass. But I had a situation where clients didn't realize that they needed to update their plan until they came in and contacted me about something totally unrelated. And we took the opportunity to review who they had selected. And the guardian they had chose was serving in prison. That's kind of a clue, if people you've chosen in their life experiences or situation where they've moved out of the country or whatever it might be, or if your relationship with them has changed, it's probably time to go in and revisit those decisions.
Oh, I neglected to mention, I'm glad you brought it up. A key reason is the role players that you've chosen, guardians, trustees. They're no longer part of your life or they've moved on. I saw a client socially this past week who said, "Oh, by the way, 2 things. I'm going in to get a stent on Friday, and I need to come see you because all of the people that I've named to take care of me are dead." And it's like, yeah, we should probably do that before you go into the hospital.
Right.
That's I don't see too many families that have young kids, but I agree with your statement. Choosing a guardian, it's a hard thing. We recently have a case. Couple died. They had kids that were 16 and 17, and they hadn't updated their wills in 15 years. Well, the kids wanted to go with their neighbors who they spent all their time with, who had kids their age, and the guardians that were named, were aunts and uncles that they barely knew that lived 2,000 miles away. And who you want when your child is 2 years old is not who you want when your child is 6 or 7 or 12 or 17.
Right.
So, and those are simple changes. You don't need to redo your whole estate plan if you just want to change your guardians or the financial advisors or who's going to take care of you. The people that you've named in Illinois, to be your caregivers are not going to be your caregivers when you've moved to Arizona, and the people that you've named in Arizona are not going to be the ones that once you've moved into a facility.
Yeah.
So that's those are all good questions, and those you know I don't know if this is true or not. It seems to be true that people are hesitant to go to lawyers because they think they're going to be oversold. We don't have to do a whole, I mean, well, and as you know from your experience in wealth counsel, uh, if we've done our job at the beginning to update what we've done or to make changes, that's easier. Plus, we probably know you a little better uh, than a lawyer that you went to that charged you a few $100s and gave you a will.
Right.
Uh, we sometimes see those and we say, well, what assets did they have? And the lawyer will say, well, I didn't need to have that information because it was a will.
Mm.
And well, and even in a trust, clients sometimes get annoyed when we tell them they sign their trust and they think they're done. And we said, okay, now here's what you've told us about your assets. Here's the next step. And there's more work for you to do to make sure that you've taken care of your loved ones. And, the older you get, the more forgetful you are. And now's a good time to stick a pin in it to make sure we know where everything is right at this moment. Because even though that may change, at least we have a starting point.
Right.
So,
Right. Well, Mark, this has been great. I appreciate your time and your advice. How can people contact you?
well, my phone number is 602-254-6008. And if you call our firm, you're going to talk to at least three nice ladies before you get to me, but don't let that discourage you. Uh, when people call us and say they want to do estate planning, we take down some basic information and we send you out a questionnaire to help you start thinking about what we're going to do. And we do a lot of video calls or telephone calls at an initial meeting just to see if it's a good fit. As I've said, I have a very direct style. Uh, I've had other lawyers sit in meetings with me and come out and say, that was horrible. You treated those people awful. and, and the answer is, I was just being honest. I was with a couple, and the wife had inherited some money, and she'd asked me a question, and the husband started explaining it to her, and I said, "Stop talking, look at me." And the lawyer that had referred him said, "They're never going to hire you." And I said, "Yeah, I'm glad."
Mm.
If he knows everything, why is he coming to me anyway? And that's so. But we're happy to help people. We're happy to say this. We need some other help. Like you concentrate on doing trusts or LLCs and irrevocable trusts and asset protection. If we have a client that has that profile, then we recommend that we bring somebody else on board. We like to be the quarterback, but we don't run the ball. We bring the people on that we need to help us. So let me say the number again, 602-254-6008. Happy to have a short call with any of your listeners that just want to know what should they do.
Right.
And happy to do that.
And then remind me, what states is your firm licensed in that you can help people?
Well, we primarily work in Arizona, but we have a couple of attorneys that are licensed in California. We regularly represent California clients, and but and I have out of state clients that we do planning for. We don't do administration or litigation outside of Arizona.
Yeah, that's great. Well, thank you, Mark. Listeners, appreciate Mark's advice and insights. You've heard me say, and I'll say it again, living trusts and estate plans do not protect your assets from your lawsuits and creditors. It's not how that works. But that doesn't mean that you don't need an estate plan. Hopefully, you've heard today that looking at it from the other perspective, we want to avoid the lawsuit that can occur if you have no estate plan. And that's called probate. That occurs when you're incapacitated, unable to manage your financial affairs, or upon your death. And remember, we're all about not only protecting your assets, but also protecting your legacy. Mark, I'm sure if we had more time, we could share war stories about how families love to fight over money. In fact, it's often not the money, but physical, tangible property. I had a client that fought over the Electrolux vacuum and the ugly leather chair. Why? Because she didn't want her brother to get it. It's just absolutely crazy. So it's critical that you worked with an experienced estate planning attorney when creating your plan. People want to do LegalZoom or any of these cheap alternatives like a document preparer or paralegal. What a mistake, because that often leads to mistakes which become more costly. And the last thing, listeners, I'd remind you is don't procrastinate. If you fail to plan, your assets will be tied up in court, and we want to avoid that. So, Mark, thank you so much for being part of us today.
Thank you. This was like the fastest half hour ever. We could talk about this topic and others related for a very long time. Thank you very much. I enjoyed spending time with you.
Well, thank you. Take care, everyone.
You've been listening to the Asset Protection Show, expert strategies by attorney John Skabelund. For more information, go to assetprotectionshow.com.
This content is legal information only and not legal advice. Viewing this content does not create an attorney-client relationship. Mr. Skabelund is admitted to practice law in Arizona, and he may be reached at ultimateassetprotection.com.